Hi, this is Mary Jean Ziska. It is the 5th of November 2015. It's 12:40 p.m. and I am still trying to remove the bankruptcy that is found on my public records. This is something from LifeLock, but let's go. I didn't want that hanging in my face. See, 12:40, the 5th of November, which is Thursday. It's a lovely 79 degrees here in the Sarasota, Tampa area, and I am attempting to call Diane Jensen. She is allegedly the Chapter 7 trustee whose office is located in Fort Myers. The trustee was the person who was supposed to handle all of the paperwork. I received her telephone number from super nice lady Dana, and I have part of an address. It's P.O. Box 15 or P.O. Drawer 1507 in Fort Myers, Florida 33902. I tried it a minute ago. I got the answering machine, so I'm going to try it again. She might be out to lunch. It's 12:41 p.m. So maybe I should actually wait until after lunch. The other telephone number is to report to the U.S. Trustee Office, which is 813-228-2000, which would lead me to speaking with the trustee. I've recently learned I need to, first and foremost, I need to file a motion to reopen the case. I was told by Dana that would be a charge of $260 to open up the Chapter 7 bankruptcy. Remember, it started as a Chapter 13, was moved to a Chapter 7, and all done fraudulently. Started by Linda Yeager and Marion Gregory of July in 2014. There's also Antonella Scarpa was involved, bullying and pushing her way into making sure that this can ruin my life. So once the case is reopened, I found various cases, Virginia, South Carolina, where an expungement needs to be created that would then remove the Chapter 7 or Chapter 13 bankruptcy from public records and permanently remove it so that no credit reporting agency would be allowed to, in the future, now, even within the next 10 years or forever, would be allowed to report it on my credit reports, which is the problem and why I am not able to rent a car. It's the only thing on my credit report, and it is a complete and utter mess. I've never talked to this Linda, or Diane, sorry, never talked to Linda. I actually never met Linda Yeager, the person who filed the bankruptcy, but I also never spoke with nor met Diane Jensen, who is the Chapter 7 trustee. I'm not really sure how she was able to decide that she had all the proper paperwork, and that should be interesting to talk to her, which is why I wanted to create this video. So we're gonna have to do it, I think, after lunchtime so that we can have it recorded and we can actually then go from there. I wanted to once again mention the 10 different points that I created. I created a video on that, and that is for the fraudulent Chapter 7 bankruptcy to be removed. And the reference number for the bankruptcy is 1408053. C as in Charles, E as in Edward, D as in David. Listed on my credit report, filed in Tampa, 7/11/2014. I think the one woman actually said the Chapter 7 may have been filed in Fort Myers or Naples. I found some really different case law, and I wanted to go over that in a video and be able to actually reference the different information. There was a really interesting case that was in Virginia, and that I've been going through. This is the bill for the senator. And let's see if we can find that real quickly. There is one case, and this was actually where a motion to rehear and vacate revoked Chapter 7 on August 20th, 1985. This motion requests the courts to rehear Whitener's case and expunge it from the public records. This was the bankruptcy number for Larry Bruce Whitener, Whitener. The bankruptcy number was 80-00389, citation CIVA.NO.73-2512, and this was concerning an expungement. So this, learning and learning more and more and more about all kinds of fun information. That was one case that I found. There was one case, different articles, of course. This was a case that I first found that actually supported an expungement. And this was a case in South Carolina where a lawyer actually filed without the basic permission of the actual people they were filing a bankruptcy for. And this is in the United States Bankruptcy Court for the District of South Carolina. It's a case number 05-14920-JW. It's for Chapter 7, and it was entered into the court system November 2nd, 2006. I found about this case reading some of the various information and documentation on removing a bankruptcy. It mentions this is in regarding Johnny Storay Story and Patricia Storay, who were considered the debtors. This matter comes before the court upon pro se motion to disgorge fees and motion to expunge bankruptcy case. Once again, the bankruptcy case number 05-14920. Motion filed by Johnny Storay and Patricia Storay. So it was filed by the actual people. The Storys seek to return the return of attorney's fees paid to their attorney Blaine T. Edwards, and to expunge this bankruptcy case on grounds that Edwards provided incomplete service and that the Storys did not authorize Edwards to file this case on their behalf. So we can actually use this case, I believe, because it's bankruptcy is a federal offense when created fraudulently. So that case, this case concerning Larry Bruce Whitener, this was actually, let's see if we have documentation. Let's see, Whitener sought to amend his bankruptcy court file so that credit bureaus would no longer report that he had discharged his debts in bankruptcy. On April 24th, 1985, Whitener, proceeding pro se, filed a motion to rehear and dismiss Chapter 7. The motion was heard on May 7th, 1985, and an order was entered on May 17th, 1985. The involved case may be reported as revoked. However, instead of using the term revoked as requested, credit bureaus reported that Whitener's bankruptcy petition had been dismissed. Believing that the item bankruptcy dismissed provided a misleading impression of the true financial history, Whitener attempted to persuade the bureaus to delete the item from his report. Apparently, he was successful with all except TRW, TransUnion Incorporated. Whitener's next step was to file a motion to rehear and vacate / revoke Chapter 7 on August 20th, 1985. This motion requests the court to rehear Whitener's case and expunge it from the public records. Whitener pro-offered an order that would incorporate all terms of the May 17th order, but in addition provide that all reference in public records be expunged and that further public access to this case be reported as no public record found. In effect, Whitener requests the court to wipe his bankruptcy slate clean so that there will be nothing on file for the agency like TransUnion to find and report. That's something I'm baking and cooking for dinner. So that actually is what needs to be done to the Chapter 7 bankruptcy. Started as a Chapter 13 form that's found on my public records that I did not create, did not pay Linda Yeager, never met Linda Yeager, never signed any paperwork. The case in Virginia, great case in Virginia that actually goes through point by point for the Virginia bankruptcy code and all of the violations of the bankruptcy code. So I'm going to re-look at the bankruptcy code to make sure that I have all points noted for every violation concerning a wet document, a wet signature, which has to be actually created for schedules. It had to be created for tons of different information that allegedly Linda Yeager was supplying me if I had been the person, which I did not create this bankruptcy. So anyway, there's another article. It's debtors in pretension. It's in light of the growing incident of identity theft. Practitioners need to understand how to expunge a fraudulent bankruptcy. And identity theft references anyone who uses my name or a person's name, uses their information, and actually then it's illegal to create such documentation without that person's permission. Such was the bank account that was opened and the money that was stolen from Social Security, which is a felony, and then also this bankruptcy is also considered a felony. It's a federal offense. Okay, this is the United States Bankruptcy Court, and this is a great case. Created the Eastern District of Virginia, the Norfolk, Virginia. The case number is 13-73077-7 SCS. S is in Sam, C is in Charles, S is in Sam. It's for a Chapter 13 case. This actually goes through all the history. It goes through point by point all the different violations concerning every single violation that this lawyer. It also goes into reprimand and sanctions that were enlisted for not only the lawyer was actually suspended for 3 months, but also the law firm that condoned the creation of a bankruptcy. And let's see, this is the voluntary petition under Chapter 13 of the Bankruptcy Code was filed by Peter F. Zooberg, Zooberg, Esquire, and the law firm Office of Philip R. Boardman, PC, purportedly on behalf of TC on August 20th, 2013, docket number 1. And then it goes into the variations of the trustee alleged in the motion to expunge that the petition was filed by Zooberg without TH's signature or authorization in violation of Local Bankruptcy Rule 5005-2 and the Case Management Electronic Case Files Police Statement made effective on July 30th, 2012. The motion to expunge further alleged that the petition contains several misrepresentations, including the representation made by Exhibit D, accompanying the petition, that HT had completed the required pre-filing credit counseling course requirement, when TH had not in fact fulfilled this requirement. I purposely and specifically, once I found out that all of this was that I actually started fighting all of this, I did not do any classes. There should have also, according to this documentation, there should have been a certification and an actual certificate upon the completion of the debt classes, which of course I did not do because I was not filing for bankruptcy. Also within this case, which is great, it's super long, 49 pages to be exact. Let's see. Here it is. Upon review of the pleadings filed by the U.S. trustee with the consent of all of the parties, the court granted the motion to expunge to afford relief to HT docket number 28. See also July 9, 2014 transcript at 12. Period. The order granting the motion to expunge was entered on July 18, 2014. So this is a more current case that I would like to use to support the petition for expungement, but I'm also looking for case laws in Florida. And there have to be other cases that were created completely and utterly fraudulently. I've been reading different articles where sometimes a husband or a spouse, a family member, or even just an identity thief out and out creates these to hide their debt and to actually, to help themselves, not to help the victim whose name they use. So this case actually goes into the findings of the fact, which I think I want to do a whole video all on the findings of the fact. This goes on to the completion and the pre-petition credit counseling, which they never did and I also never did, about the financial affairs which I never spoke with Linda Yeager, creating any type of history, telling her any of my financial affairs. In fact, in here at the very end of the case, they found it grievous that as a third party was able to to be able to actually tell this lawyer, Zuberg, about the financial situation of the person that they were filing a bankruptcy petition for. This person, the lawyer, never actually talked or found out from the person themselves, which is the same fact. Never spoke with Linda Yeager. All the information that she would have heard of would have been through a third party, either through, I guess, Antonella Scarpa, through her own situation. I know she, in this case, it actually also goes into various infractions where due diligence was not done concerning the history of this person's credit. I have had no debt, and so I had no credit card debt, no car debt, should have had no mortgage debt, and it's just unbelievable how this case follows point by point the violations that these lawyers did, that also Linda Yeager did. I also want to mention, I also want to mention that there were two different Better Business reports that I filed against Linda Yeager, and it looks like I'm going to have to actually go. I had one person that I spoke with on the phone concerning this wanted me to file criminal charges because they believe that that would be a way of alleviating the 10 years of bad credit that I did not agree to, did not do myself, did not do it, ask for it to be done on my behalf, that I fought every moment of the way. I know when I even spoke with Linda Yeager, she told me that there was a $500,000 debt on my condo, which was a complete and utter lie. And she also, no due diligence on the identity theft from 2012, the fraudulent counts that were actually placed on my credit report, including a fraudulent mortgage, 7 fraudulent accounts, or any of the work that I had done to actually clear up those accounts and to remove the fraudulent mortgage. It's just unbelievable that this can actually happen in America. Okay, then also the next point is the proper venue. Finally, the court finds that Zuberg made a misrepresentation in the petition regarding venue. The petition indicates that venue is proper in the Eastern Division, and this person resided in the district for 180 days. On my credit report, Experian in particular, they have my mother's address, 9202 Vanderbilt Drive, listed as my address. They also, I mentioned and had been talking to the people from Experian in the dispute fraud department. They also listed her address, and the assigned identifying number for her address is also listed on the identifying number and reference number and identifying number for the bankruptcy. So since I do not have a copy of the bankruptcy, I never filed it. I also contacted one agency that told me the bankruptcy paperwork itself consisted of 200 pages. They wanted me to pay anywhere from, I've been told in 2 different variations, that it would be $80 or it would be $95, depending on who I actually utilized to get the paperwork that I didn't create. Then on top of that, another $260 to file criminal charges, $7,500 to actually even just do an affidavit that of the violations of the bankruptcy code to make a legal document. That would be $2,000. So this is getting very pricey, and it's still not finished and is still heavily weighing on my shoulders, my heart, and my finances and my credit. Okay, so this also points out incorrect venue. Due diligence, which I mentioned briefly, that the due diligence, and here it even mentions, it is never sufficient due diligence for any counsel to file a bankruptcy petition founded solely upon asking a debtor for her social security number and whether she has taken a credit counseling course, which is all that this Zuberg lawyer did. Linda Yeager didn't even do that for me. I've never met her, never spoke with her on the phone. I have an email from her from October 7th claiming that she would dismiss the case and that she apologized and said she was sorry and that she was only trying to help. So let's see. The proper filing for a bankruptcy petition necessitates a much more extensive investigation into a debtor's circumstances than was conducted by Zuberg on August 20th. I can go in point by point what wasn't discovered also by Linda Yeager, or I had one person who was briefly going through the 200 pages that consist of this bankruptcy and mentioned that Linda Yeager had been fired. So I'm not sure if Linda Yeager was fired after the chapter 13 and perhaps she did try to dismiss everything. I don't even know that. And then another attorney was retained who then went ahead and filed a chapter 7 bankruptcy. Not on my behalf, but also another lawyer then, if that was the case, never met, never spoke with at all. Okay, let's see. After the due diligence, then there was also, they go into a whole history of every single of the conversations, of the meetings. Never had even Linda Yeager come to my house. I tried emailing her, asked her to remove it, asked her to stop. Let's see. Here they actually, on this case, the bankruptcy filing, the motion to impose sanctions, also was conducted because the firm also conceded that the failure to produce the original signature means that the signature does not exist. Taken in conjunction with HT's testimony, which the court finds more credible that of Zuberg, which was the lawyer, the court concludes as a finding of fact that Zuberg failed to obtain the wet signature. And then I found out, even through this, that not only does a signature have to actually be created, but that the lawyer has to agree or has to probably sign and say that they witnessed it, or that they are also mentioning that, or they're accepting whatever signature as a true and authentic signature. Even if it was done electronically, they have to take accountability for a signature either being true signature or not being a true signature. Then it goes back into the classes that were never taken. It even gives an excerpt of a conversation. It goes into the address, which I mentioned is pretty similar. My address was screwed up. I even contacted 2 or 3 different times. I contacted the people from Experian. They said that there was no problem with my address being listed as my mother's address. They also said right now, this person, actually the last person that I talked to, was very helpful about not only removing a Whisperwood location or address that was for a multifamily home off my credit report, but also was going to do an investigation concerning how many things were listed as mine, as my debt, or when it was my mother's address that was listed as my address. I think a couple of the people that she actually has had as renters at her house may have also been using my information and been assisting in identity theft in the past, because I know for the 2012, some of the items were so easy to actually remove because my driver's license has my address, 5632 Whisperwood Boulevard, Unit 1601, Naples, Florida 34110, versus the address that was listed on the actual accounts. Here it goes in here on page 20 of this actual document. It says, indeed, the court finds that Zuberg, that's the lawyer again, conducted essentially no investigation of TH's personal and financial circumstance. Instead, the court finds Zuberg relied on insinuations made by a third party with whom he was acquainted. And this is also the same insinuations that Fifth Third Bank opened a bank account with a lie that I was under 18 years old, that I was incompetent or incapacitated, and I believe the same type of lies were also told to create the bankruptcy to hide the $65,000 of debt that was created from a 2012 identity theft. And none of this was done with my permission. None of this was done on my behalf. And it was done with a lot of lies, a lot of manipulation, a lot of bullying, and absolutely, completely, and utterly unacceptable. On page 29, it even further states, similarly, the court retains jurisdiction to sanction an attorney that practices before it after a bankruptcy filing is expunged. Expungement of a bankruptcy filing is an extraordinary remedy, and then they give a couple different cases. In a bankruptcy case, the purpose of expungement is to protect the legal rights of the debtor, and the remedy is available only in certain extraordinary circumstances, such as when a debtor did not authorize the filing of the bankruptcy purportedly made on her behalf, which is my case. Expungement is directed towards the public's notification of bankruptcy filings, essentially rectifying via purging a fraudulent or otherwise incorrect filing. Expunging a bankruptcy filing of joint debtors who signed a bank petition, which is not my case at all, unless somebody's also put my information on a house or another debt, which I did not agree to. Let's see, the dismissal, closure, and expungement of T.H.'s case does not eradicate the egregious conduct committed by Zuberg and the Boardman firm in this case. The expungement of this case was an equitable remedy fashioned solely to protect H.T.'s interest by removing her case filing from the public record. Likewise, the expungement of the case does not obviate the existence of the filing of the case nor the troubling circumstances surrounding the filing of this case. Accordingly, the court's discretion to impose appropriate sanctions against Zuberg and the Boardman's firm is unchanged by the expungement of T.H.'s case. They went into the lawyer's conduct. They also, let's see, here there was a mention of the bankruptcy petition schedules, the statements. All of those had to have signatures attached. Let's see, and at the very back, at the very end, this is already running into 27 minutes, the authorization to file the bankruptcy, which they never had, and let's see, they talked about personal conversations, the misrepresentation in the petition, and Exhibit D. Federal Rule of Bankruptcy Procedure 9011 provides that by filing a document in this court, the attorney certifies the veracity of the representations made and the appropriateness of the filing. Let's see, the court depends on the veracity, integrity, and competence of the attorneys that practice before it. So he also mentions, as officers of the court, attorneys have a special responsibility for upholding the quality of justice within the judicial process, which of course was not done in my case as well. I'm going to skip ahead. If you want to take a look at this case, it's absolutely amazing, but it also shows the corruption, and let's see, it also mentions the Zuberg, which is the lawyer again, failure to fulfill his professional responsibility obligations. And then it mentions even just the Black's Law Dictionary, which defines diligence, reasonable diligence, and Black's Law Dictionary of due diligence as defined as the diligence reasonably expected from and ordinarily exercised by a person who seeks to satisfy a legal requirement or to discharge an obligation. A lawyer should act with commitment and dedication to the interests of the client and with zeal and advocacy upon the client's behalf. This is in Virginia, so it's a Virginia Rule of Professional Conduct 1.3. Diligence includes not only an adversarial strategy, but also the vigorous pursuit of the client's interests in reaching a solution that satisfies the interests of all parties. Zuberg's failure to act with reasonable diligence in this case are manifold. Zuberg failed to act with any semblance of diligence in filing the petition by failure to ensure that TH had authorized the filing. It even goes further on about how disappointed the court system is. The obligation to communicate regularly and appropriate with his client about the client's matters also did not happen in the case that was filed by Linda Yeager and Marion Gregory. And let's see. An attorney has an obligation to appropriately counsel a client and appropriately explain the law to allow the client to make an informed decision. Also not done. So I'm going to still need to go through, even though I found 10 violations of the bankruptcy code, I'm going to go point by point through the bankruptcy code because I'm sure there's quite a few more violations. And it looks like it's going to be a costly endeavor to try to fix, again, what these people have done to my life. Let's see. The Federal Rule of Bankruptcy Procedure 9011 similarly provides that an attorney's signature on a pleading filed in this court constitutes a representation that the attorney had a good faith basis in fact or in law for filing the pleading. Also not done. Well, not that I actually, no good faith was created to for creating this bankruptcy, Chapter 13 or Chapter 7. And then this case actually goes into Boardman's firm conduct. Then it actually goes into the sanctions. There was a 3-month suspension for the actual lawyer Zuberg and $1,000. Let's see, suspending the attorney for a period of 3 months. The court concludes that Zuberg and the Boardman firm should pay a fine of $1,000 for which they are jointly and severally liable to TH, representing the disgorgement of the fee paid by Bloom for the filing of the petition in this case. The court finds that the sanctions against Zuberg is the appropriate sanction designed to deter Zuberg, Boardman, and other attorneys who practice before this court from repeating the most disturbing conduct in this case. The sanction shall be paid in full within 30 days. So they actually think it's the most horrid thing that they'd ever seen. Wait till they actually take a look at this case. Anyway, this is Mary Jean Ziska. It's now 1:12 p.m. I've got to go finish baking and cooking for this evening's meal. I'm trying to fix this, again, most horrid situation that I have to fix with a fraudulent bankruptcy created July of 2014. If you have any case law that actually supports the expungement of bankruptcy, please contact me, www.mysearchforjustice.com, Mary Jean Ziska, and it is the 5th of November, 2015. Take care, God bless, and contact me and help. You can find me on Skype, What About Mary 1, and you can actually put a note that you have a case, or even just put the case, and then I'll agree to actually speak with you. Or I'm going to create a email address specifically for these videos so that content and any case laws or any assistance can be directed to those. Okay, hope you're having a great day. I'm working on it, and working on towards having a great life again. So thank you for your time, and once again, this is Mary Jean Ziska, www.mysearchforjustice.com, and take care. God bless. Have a great day. Bye-bye.